So here again, the local constitutional kook out here in California, and maybe the most important video I've ever done because I recently made some connections, and I should have made them a while back. I mean, they're there; you just have to look at it and see it. Um, but now I think we have the issue that's going to get us all out from under because it occurs in every case. Doesn't matter whether it's criminal law, traffic court, child procurement syndicate, anything like that. Simply doesn't matter. And the homeowners association, there's another one on my hot list as well. Because the big deal is that what we're dealing with here, like it or not, right or wrong or good or bad, and if you've been watching my videos, you know front and center for me is the non-existent 14th War Amendment. And here we go again, because what that amendment did, and this is the new flash I had looking at Article 3, Section 2, U.S. Constitution, where it states that the federal courts have jurisdiction over foreign states. Like you, it never occurred to me what that really meant, because that 14th Amendment, and it was never ratified, so you're going to learn that if you get all my paperwork and everything. It's a stunning development in 1868. Send me an email, uwinningcourt@gmail.com. You'll learn all about that. Not only doesn't exist, never has existed. And a big reason for that is what they did. And they didn't bother to tell anybody who ratified the amendment. Not that it matters, because as you'll learn, this amendment would have had to have been ratified by people in conventions of the states, which, as far as I know, has never happened at any time, and it sure as hell didn't happen with any of the war amendments either. But that said, what they did was create a jUS SOLI foreign state. That foreign state can be identified as the District of Columbia, among other things. Nevertheless, it's a foreign state. And that's where we get them, because there's a lot of you are well aware. You try to go in and file documents, even if you have some good ones like you can get from me. Send me an email, uwinningcourt@gmail.com. They either don't get filed, and all of this has happened to me, by the way, or the clerk of court changes my non-statutory federal writ of habeas corpus into 28 U.S.C. 2254, not only a statutory enactment, but a war act of the 39th Congress, consistent with the fact that the 14th Amendment is a war amendment, and you never get heard. Those are the three magic words, because that comes out even if somehow they're in judicial courts. And I personally think and believe we can prove that that amendment did away with all the sovereign independent states admitted into this union. There are no judicial courts anywhere in sight, not to mention trial by jury according to the course of the common law, where a jury can rule on the facts and the law. That goes back to Magna Carta, for crying out loud, and those racist framers are well familiar with all of that, and they put it all into the Constitution. It has to be there. It just has to. Not if you're a 14th Amendment birthright citizen. No, that's irrelevant. But to the sovereign body politic of the nation, and even inhabitants of states and inhabitants of territories have at least the right to trial by jury and habeas corpus, both of which have disappeared like a fart in the wind with today's martial law military government in place, courtesy of the 14th Amendment. So that said, what we can do, and I've been doing, as some of you have been following my videos, a non-statutory supremacy clause removal to a federal circuit court. That's a winner-winner chicken dinner if we had some honest backroad bastards in there and neutral magistrates instead of state bar association attorneys, all of whom are unregistered foreign agents of at least the City of London. This is a dead bang winner. You get in there, the case gets dismissed. See you later. Have a nice day. Now we have more leverage with the foreign state. That's clearly and unambiguously mentioned in Article 3, Section 2. Therefore, even if a statute was necessary, and it's not, I mean, we'd use habeas corpus, if nothing else, pursuant to Article 1, Section 9, Clause 2, which can't be repealed except in declared states of rebellion or invasion, none of which is yet known to exist. This is our remedy. So, among other documents you're going to get from me is a letter to the presiding judge of the Federal Circuit Court demanding answers to our questions on the record in brief filing documents. And we start out with the fact they want a filing fee, and it may only be $5, but in undefined dollars, and you're going to learn those dollars are defined, if at all, by the president acting as commander in chief of the armed forces. Doesn't work that way. And the Supreme Court has ruled in a case called Plaintiff Nevada, I believe, 6 Law 35, 1867, if the government can tax a man $1, they can tax him $1,000. Why not make the filing fee $5,000, which is a hell of a lot more honest than only the rich fat cats out there in New York can afford filing fees like that? You know, if there is one, and in undefined dollars that circulate in interstate commerce, that's New Jersey Steam B Merchant Bank 6 Howard 344, and those make you a hypothecator of goods or stipulator in the Admiralty. Bank of Columbia v. Oakley 4 Wheaton 235. But if we're in Admiralty, this can't be, because everything they do in these quote-unquote state courts is in this jurisdiction. And as those racist framers were well aware, Admiralty is a jurisdiction foreign to our Constitution and unacknowledged by our laws. No state court can exercise it. Where the hell are we and why? We have a right to know and to be able to fix it. And that's what we're going to be able to do here. Because now they have this jurisdiction, and the documents that you get, you're going to read some excerpts from Justice Joseph Story. He was on the court 200 years ago, the early 19th century, the greatest expert then and now on the original intent of the Constitution, and the current justices know who the hell he is. And he says that judicial power must be vested. Those courts have to be there, especially if we don't have any state courts and state judicial courts, which in an earlier era did have concurrent federal jurisdiction. You'll learn about that too. Send me an email, uwinningcourt@gmail.com. It's an exciting time to be alive here. We're getting closer and closer, even in the quote-unquote election year. You'll learn more about that later too. But it really is, if we get in there. And now the big deal is if we set the document record correctly, and they deny it again, and we're demanding that the presiding judge make written judicial orders on our filing documents. If that doesn't happen, now we get to the U.S. Supreme Court with a writ of habeas corpus, non-statutory, Article 1, Section 9, Clause 2, and or a writ of mandate to order the judge in the lower court to do his discretionless ministerial duty and state for the record either that we have the court that we want to get into and the documents are going to get filed there. And what that's going to mean, people, is all these LLCs out there, Chase Bank, your homeowners association, anybody like that, mortgage banksters, do not have any standing in judicial courts. That's a default judgment for us. And that's how it damn well should be. So that happens, the case is over. You get your property back, you get your freedom back, more importantly, your children back from the Child Procurement Syndicate, another administrative agency. And you send me request for information at uwinningcourt@gmail.com. I'm going to send you a case I've highlighted called Axon v. FTC, decided almost a year ago by the Supreme Court. And it's a stunning, not to mention unanimous decision. And you read that and you don't know what you're looking at. You're going to think that you're reading your case, because that's exactly what it is. Another administrative tribunal. That's all they have. but they can't volunteer us into it. We haven't made a voluntary, knowing, and intelligent waiver of rights anywhere in sight. And that's how good this is. But you read this, and note carefully, by the way, the opinion of the court is not by Elena Kagan. It looks like it is. The real opinion is the concurrences of Justice Thomas and Alito, and it's plain language. And they're, by the way, about prep to come out with another one this term, a case called SEC versus Jarkissi out of the Fifth Circuit. And the Fifth Circuit in Texas threw the SEC out on the street and said, get the hell out of here. The Supreme Court had no reason to hear this case, except now they're going to say it again like they did in the Exxon case. I hope unanimously. That may or may not happen, but with much clearer language. And it's going to get through to a lot of people, maybe even some members of the mindless mainstream media, aka 3M Inc. Inc. So we'll see how that plays out. But it's exciting to be in these times and to have a real chance to turn things around and get our Republican form of government of defined and limited powers back and end this elective despotism and send it back over there to Pyongyang, North Korea, which is its real home anyway. We don't want it. They're sure as hell welcome to it. So it's just great news here all the way around. And it's a lot of hard time and effort on my part to get this far. I'm certainly going to do it, what I was put here to do, by the man upstairs. I'm thankful for that and thankful for the great health I have at the age of 75 to be able to keep doing what I'm doing. Whether I get to the finish line with you, I don't know, but I'm going to get a lot closer to it, especially in the next couple of terms on the Supreme Court, because once we have the quote-unquote election, unless Biden steals this one, and he might not even win in the states, it's going to make it real hard to do that. But now the court's in control because they'll get two younger justices to replace Thomas and Alito, and we'll be there for the next 12 to 15 years. And now we will get a lot of answers and get them a lot more quickly than we've been able to do to this point. It's an exciting business. I know I've talked a bit more than I should here. But that said, send me an email, uwincourt@gmail.com. Remember to subscribe, like the video, tell your friends, get word out. We are on the verge of victory here. So that said, remember to do all those things, subscribe, like the videos, and wait for other videos to come up too. I'll be doing more, I think, before the week is over here on April 16th now. And we'll see you from there. Thank you.